and get this meeting started and call the meeting to order. The only thing we have on our agenda for today is one bill hearing over House Bill 2607. We'll go ahead and open that hearing and request that Natalie give us an overview.
Thank you, Mr. Chairman. House Bill 2607 clarifies the time limitations for habeas corpus claims. Section 1 amends KSA 60-1507, that's the habeas corpus statute. Under current law, a habeas corpus action has to be filed within 1 year of either the final order of the last appellate court in this state to exercise jurisdiction on a direct appeal, or the termination of the jurisdiction of that court, or the denial of a petition for writ to the United States Supreme Court, or issuance of that court's final order following a granting of that petition. This bill would add that an action would have to be filed within 1 year of the decision of the district court denying a prior motion under this section, the opinion of the last appellate court in the state to exercise jurisdiction on that prior motion, or the denial of the petition for review on such prior motion, whichever one of those three is later. And I can take any questions.
All right, committee questions? Representative Howell.
Natalie, I was wondering if two things that maybe you could help me with is, one is, could you kind of give me a little bit of a practical real world example of when habeas corpus would be used, because this is way out of my wheelhouse of knowledge. And then also I'm wondering, is there a difference between habeas corpus and a writ of habeas corpus? Because I don't understand that either.
Thank you, Mr. Chairman. I am the much less knowledgeable Natalie in this room about habeas corpus. You're going to hear from a much more knowledgeable one in just a second. But essentially, someone would file a claim for habeas corpus, which writ is basically just like saying it's just like legalese for filing a claim. And what that motion would be is that you're imprisoned for some illegal reason. So actually, if you read that first sentence starting at line 7, a prisoner in custody under sentence of a court of general jurisdiction claiming the right to be released upon the ground that the sentence was imposed in violation of the Constitution or some other law, or they don't have jurisdiction. So it's essentially someone who's in prison who thinks that either their sentence was illegal or for some other reason they shouldn't be in prison under that sentence.
Additional questions for this Natalie? All right, seeing none, thank you, Natalie. We'll now welcome the habeas corpus, Natalie Chalmers, from the Attorney General's office. Welcome, Natalie.
Thank you, Representative Owens and members of the committee. My name is Natalie Chalmers. I didn't do a good job introducing myself the last time I was here. I am an Assistant Solicitor General, which is a fancy way of saying I handle appeals. I also do have an active 1507 caseload, is what we call it. So there are actually two different types of writs in Kansas. There's a 1501 and a 1507. 1501 challenges conditions of confinement. It's often, I would like magazines, someone is torturing me, et cetera, like that. The 1507 is almost exclusively used, you can raise other constitutional challenges, but it's going to be constitutional challenges to the conviction or the sentence. And typically what it's saying is, I had a trial and my counsel was not constitutionally effective. And so they're trying to challenge that they should get a new trial because their counsel wasn't good enough. What this bill is seeking to do is, we already have a 1 year time limitation for that. It happened in 2016. We called it the Vontris fix. When we did that, we kind of inadvertently forgot that I wouldn't say forgot, but did not handle the fact that in Kansas, unlike in the federal system, you can actually challenge your habeas counsel. So you can challenge your 1507 counsel as being ineffective. In the federal court, you can't actually do that. You have no right to counsel in 1507 or in federal habeas, so there's no ability to challenge it. So it's been kind of unclear how long they have. So for a person challenging their trial counsel, they only have 1 year from the case being final at the appellate level. And so we've been arguing about, well, do you only have 1 year to challenge your 1507 counsel? I'm going to call this case Rowell, R-O-W-E-L-L. I don't actually know how to say it, and if anyone wants to call it something else, I welcome that. That was decided on June 4th of 2021. It's a Court of Appeals opinion. Fun fact, the Court of Appeals panels are not actually binding on each other. they can actually disagree. So it's binding on the district courts, but not any other appellate court. And it held that they get a year from the mandate. We are asking for a different rule because in the federal system, under the 10th Circuit, they get a year from the last opinion that was issued or the denial of the petition for review. So we're trying to mirror the federal rules and somewhat out of a kindness to defendants so that they do not get, I was about to say screwed over, if they do not get kicked out of federal court because they didn't meet the right deadline. So we're now mirroring the federal process and we're giving them 1 year. I know that Clayton Perkins here, who you listened to testify the last time I was here, is asking for an amendment. I'm pretty ambivalent about the amendment. This case has been around since what he wants is something that says that this won't apply until a year from whenever this law is codified. They've had since June 4th of 2021 to file their 1507 against 1507 council. They've been on notice. I don't really feel like they need another year, but if you want to give it to them, if that's what makes this bill pass, great, willing to do that. It would be even better maybe if you then make it effective on publication instead of in July, but I leave that to your discretion. So that's essentially what we're trying to do, is we're trying to largely codify Rowell, but set it with the federal, and then keep 1507. Yeah, you have a year from when your 1507 council's appeal is not totally done, but when the opinion issues or the petition for review is denied. The difference between Rowell and the rule we're asking for can be about 14 to 21 days, so we're not asking for a long period of time. The mandate usually issues sometime after 14 to 21 days. Not exactly. They have a rule on it that I am not privy to. It's the clerk's office rule, but most of the time it's about that. The reason we want this is, one, for defendants and for the state, it is a hard to prove. The defendants have the burden to prove their counsel is ineffective. It is much easier for them to do that when counsel still has their files, when counsel remembers literally anything about the case at all, and when witnesses are still alive. We've had multiple 1507s where witnesses have died and then they can't prove prejudice. We've had multiple 1507s where counsel has destroyed their files. A lot of them only keep them for like 10 years. So the faster these go, the faster everyone gets the right result. And that's the reason we're doing it. Also, more importantly for the state, is finality for convictions is important to victims. So that is why we're asking for this 1 year time limit. I will stand for any questions.
Thank you, Natalie. Representative Smith.
Thank you, Mr. Chair. Try to put this, I was trying to organize it in my mind, and hopefully it comes out that way. So on a 1507 habeas corpus, you currently have 1 year, correct?
You have 1 year to challenge trial counsel.
Right,
Yes.
right. And then if in the middle of that, you get your habeas corpus 1507 trial or hearing, does the tolling on that pause? In other words, if you have a second 1507, is that part of the problem that we're running into, or?
We have issues with what we call successive 1507s.
Yes.
Where, and they're not supposed to be permitted. The statute says, literally, the sentencing court shall not be required to entertain a second or successive, sorry, I know I read really quickly, motion. The Kansas Supreme Court is a little kinder to defendants than the rule or the legislator has what is clearly set forth in legislation. So sometimes you can actually have multiple 1507s going at a time against trial counsel. This particular statute only targets 1507 of 1507 counsel. So typically they only have one at a time. Most of them do that, but every now and again I've watched them just file over and over and over and over again. And that's usually when they're not going to the appellate court for some reason. They're just staying at the trial court because they think I don't know why, but I assume it's they think they can get better.
I feel like I have a second part of that, but I'm going to wait. I'm going to listen to further testimony and I'll try to digest that. Thank you.
All right, additional questions, committee? Looks like everybody has a good grasp on habeas corpus.
It's great. It
So,
only took me several years to learn it, so
there
you're doing
you
great.
Thank you, Natalie.
you.
All right, are there any other proponents here wish to speak on this bill? All right, seeing none, we'll move on to our neutral conferee, Clayton Perkins, Kansas Association of Criminal Defense Lawyers. Welcome, Clayton.
Good afternoon, and thank you for having us here. I am Clayton Perkins on behalf of the Kansas Association of Criminal Defense Lawyers. Sorry. And we are neutral on this bill. Part of why I wanted to be here today just was to clarify, because last year this committee heard HB 2190, which we showed up in opposition to, and that contained other substantive changes to the KSA 60-1507 statute. It also contained this statute of limitations change, which wasn't a focus of our concern last year. So we're showing up neutral here. Defense lawyers don't like the 1 year statute of limitations in 60-1507 in general, I think, because we want our clients to be able to receive that relief at any point, but that is also a battle that we lost in 2003. So I understand that's going back a ways. And this language, I think, does clarify the way this statute of limitations works. And it's important to have clear language in the statute because the timelines that are getting applied to incarcerated people who are filing these 60-1507 motions addressing constitutional errors in their cases. And an incarcerated person doesn't have a right to counsel to assist them with the filing of a 60-1507 motion. It's a rather technical process, and they're held to basically the standards of attorneys, particularly when it comes to the time limitations. So having clear time limitations is helpful in the statute so that they can see, and understand exactly when that date is. The concern I had, and why there's sort of this amendment language that I talk about here, is because of the difference between the role opinion standard and this statute and this language, which is the difference between the mandate date and the date of the opinion. So when a appellate court puts out an opinion, that opinion doesn't become effectively immediately. There's a period where you can, file review for a higher court or motions for rehearing. As Ms. Chalmers mentioned, is usually about 14 to 21 days. And the opinion doesn't go into effect until that period ends and the court issues the mandate, which is basically just another legal document saying the opinion comes into effect. And traditionally in 60-1507s and under subsection, say, F1, that's the date we're counting from. So that's about 14 to 21 to 30, depending on various processes, days later than the opinion issues. As Ms. Chalmers said, this is the language that we're talking about for this new subsection is mirroring federal rules, which do go from the date the opinion actually came out. So that's 14 to 30 days earlier. And that is, as she pointed out, helpful because then you're not running the risk of also losing your federal habeas chances because you're following the Kansas rule, which is just a little bit longer than the federal habeas rule. But my concern is that because the role opinion states the mandate rule, and that's the thing we've followed for a long time. When, say, I am sending a letter to a client saying that your appeal is over, you have the ability to seek habeas relief via KSA 60-1507. You don't have a right to counsel to that, and there are strict deadlines, including a 1 year limit from the date of the mandate. When we get to, if we switch that over in this language, then there's a risk once this comes into effect that we've basically been telling criminal defendants the wrong date, and then a lot of them are going to get cut off in that 14 to 30 day period when it would be timely under the mandate and wouldn't be timely under this new language. And again, I think there's good reason why to talk about it from a opinion issuing date. That's a little bit clearer anyway to understand for people because no one besides people who do a lot of appeals really understand mandates and that timing framework. But so the reason I think it would be helpful to have this type of language, is just to give basically a 1-year grace period, not because they haven't known that there's a 1-year deadline, but because if this comes into effect, June 30th, 2022, then there's probably someone if this comes into effect July 1st, there's probably someone out there who got a closeout letter from an attorney on June 30th, 2022, saying you have a year from the mandate date. And I think ultimately, if those went through the appellate process, if there are any cases struck by that, we've almost never, I don't think we've ever had an amendment to 60-1507 that applies retroactively, ultimately as decided by the appellate courts. But there's a few cases certainly that lose at the district court level on these timelines, particularly because you don't have a right to counsel and the court can summarily dismiss the motion filed by a pro se defendant without having counsel appointed. So they might just be looking at the date and not applying our normal procedural retroactivity rules that would eventually get them to know they have 14 to 30 more days. But I don't think is helpful for really anyone in Kansas for us to be litigating out those handful of cases. And I think this type of language would take care of that. And I am happy to stand for questions at the appropriate time.
All right, thank you, Clayton. Committee, Representative Heiberger.
Thank you, Mr. Chair. So your proposed deadline is just merely extending the deadline for people in pipeline right now by a year. It's not extending the time period to 2 years for everyone.
Correct. It's just you can't lose because of the new deadline change from the mandate rule to the date of the opinion rule is my idea and goal there.
All right. Any other questions? Representative Smith is thinking of a question. Okay, go for it. Representative Howerton.
Thank you, Mr. Chair. I'll let you think. So, sorry, I'm a little confused, and it's all good because I'm not a lawyer. But, so what dates would you want that to say specifically? Like, what dates does that affect that you're concerned about? What, like, people released, or help me word that.
Okay, so basically the current date we're looking at to the start of the 1 year period is 14 to 30 days after. So the date the mandate comes out, which happens 14 to 30 days after the opinion from an appellate court comes out.
So if we made this effective, what did you say now? Like, what was the terminology? Like, if we, on publication, if we make this effective on publication, who would that affect negatively?
I think
If you want to extend it for a year, she wants to do it for publication. So if we did it on publication with the disclaimer, people within these dates have extra time, what dates would that be?
I think it could be upon publication as well. I think that, like in terms of a 1 year period, so the 1 year period is going back to the fact that it's a 1 year time period. And this is specifically we're requesting that this provision not be applied retroactively. So,
Okay, so you don't want it to go backwards.
correct.
Okay.
We're not asking for more time. We're just asking that no one get kicked from this from the 1507 process because they relied on roll for the last year or for the next year.
Yeah, he has, in his testimony, he has specifically what he is requesting, actual language for the amendment that he is requesting.
Okay, great. My computer is locked out and I can't access it, so I can't look at it right now.
There you go.
I apologize. Thank
So,
you.
Yes, absolutely. So
That would be
is-
wonderful.
they're
Thank you.
Perfect. Perfect.
Windows updated and I can't get back in now. So.
Well, Windows is never mind. Committee, other questions? Representative Wheeler.
Thank you, Mr. Chair. And it went by pretty fast from someone. Something was mentioned because we don't want them to lose their federal habeas. Would you explain how that ties in here with what's being proposed either side?
Sure. So you have both a state habeas process and a federal habeas process. And the way a federal so the state process, you have 1 year according to our statutory language. The federal habeas process, you have 1 year, generally speaking, from the date of the last court to review the case issues the opinion. Okay. And so you can file under both. When you file under state habeas, that tolls, so it stops the deadline under federal habeas. And so then you can pursue your state habeas action and then bring your federal habeas after that with whatever remaining time there was on that 1 year. And I think the reason we're talking about this amendment doing it from the opinion date is because there is a risk when you file it on the very last day according to the mandate deadline that you're already over the habeas deadline. Did that answer the question, or?
All right, committee, any other questions for Clayton? All right, seeing none, thank you very much. Committee, are there any other neutral or opponent testimony to this legislation? All right, seeing no other testimony, we'll go ahead and conclude the hearing on House Bill 2607. We don't have anything else on the agenda for today, but be prepared for some long committee meetings next week. We've got a lot of work to get done in the next week. So with that, we'll be adjourned. Thank you.